Good morning and welcome to this session of the Florida Supreme Court. The first case on today's docket is Weston Property and Casualty Insurance Company versus Riverside Club Condominium Association. Counsel?
May it please the Court, Raul Cantero for Weston Insurance Company. This is an appeal from an order compelling appraisal in a case in which the insurance company denied coverage. There's a recognized and certified conflict in the districts about whether when the insurer denies all coverage for a loss, appraisal is appropriate.
Can I stop you there, Mr. Cantero?
Yes, sir.
It's not right to say that this insurer has denied all coverage, right? That's just factually wrong. They advanced $500,000 immediately after the incident. They pay out a little over $4 million to date. There's been no effort to claw that money back. How is it factual to say that they've denied all coverage on those facts?
Because, Your Honor, what happened was the hurricane occurred in September 2017. The insurer advanced money before it had completed any investigation and before the misrepresentations had occurred.
Okay.
So at that point, no misrepresentations had occurred. There was no basis to deny coverage.
I'm with you so far, but there's a basis today, right?
There was a basis in November of 2018 when it finally denied coverage because of the misrepresentations. So what you're suggesting is no good deed goes unpunished.
No,
we have to claw back that money now.
What I'm suggesting is it's not factual to say that all coverage has been denied when we're at T plus 4 years from the payout, and you're not here representing to us that there's been any effort to unscramble that egg or to try to reclaim that money. So if that's, and I realize how much hangs on this, your position is that since you've denied all coverage, then there's no appraisal that's appropriate at this time. But if we're just being factually honest, there's been no effort to claw back the coverage that was already advanced, and that, I think, does color whether or not an appraisal is in order.
Well, Your Honor, again, eventually the insurer did deny coverage and say we advanced 10% of what they're now claiming is owed. I mean, there's $37 million that they say they're in damages where we have denied coverage on. So I believe that it is accurate. It's accurate to say both, okay, that we initially provided those funds when we didn't know the actual facts. We knew that a hurricane had occurred. We knew that there was damage, frankly, from the hurricane, not even close to the extent that they say, but they never said there was a waiver of deny of coverage because we did not claw back.
There couldn't be a waiver based on something you did before their misconduct, their alleged misconduct.
Agree.
So have they ever claimed that there's a waiver because you didn't claw it back?
Yeah, well,
is that what they're saying?
They argue in their answer brief that they don't go through the elements of waiver, but they said they never tried to claw it back, which, frankly, I don't think that's relevant because we eventually denied coverage. And the issue is now, where we have denied coverage under the policy, yes, we haven't clawed back what we paid, but we've denied coverage for anything that they're claiming after we discovered the fraud. Now, whether we have to appraise those damages. Now, if we're saying that we want to claw back, maybe they're saying, well, you got to appraise because you paid. We're not. That's a whole other can of worms. And Leeward Bay, in which the same circumstances occurred because they advanced payment and then later denied coverage, Leeward Bay did not distinguish all those other cases based on those facts. They certified conflict on the question of whether when an insured denies all coverage, appraisal is appropriate.
I'm sorry to interrupt you. Could you just sort of take a step back though and give us your take on what is the law that we're even supposed to be using as our baseline? Because it's an abuse of discretion question, right? In terms of what the trial court did, because after reading everything, I'm still not even sure. Because it doesn't seem like the contract speaks to the order of things. We know we have law and courts/juries decide coverage, appraisers get to do the amount of loss, but to say that it's kind of per se unreasonable for a judge to allow the appraisal to happen and then sort of reserve the coverage thing for what's happening, I don't even know what I'm supposed to be looking at as the baseline to understand whether it's always an abuse of discretion in these circumstances to let the appraisal happen.
Well, I think what every court essentially has, the case they've interpreted is the Johnson versus Nationwide case, and through that also the Lycia case, both from this court. And they've frankly interpreted in different ways. They say it doesn't apply, or they say that it does apply.
Well, we would look at the Florida Insurance Code to see if there's anything applicable there, right?
You would, but there's nothing, nobody has argued that there's any applicable code provision that would govern these circumstances.
So then it's just a matter of looking at the insurance policy itself and following what it says, right?
Yes, Your Honor, and the policy itself, and this is on page 80 of the record, says, with respect to all persons insured under the policy, we provide no coverage for loss if, whether before, during or after a loss, any one or more persons insured have intentionally concealed or misrepresented any material fact or circumstance, engaged in fraudulent conduct, or made material misstatements.
Right, and then there's under paragraph 8, it talks about mediation or appraisal on pages 14 and page 14 of the policy, right? There's under the paragraph.
The appraisal provision?
It says mediation or
yes.
appraisal in the policy.
Yes.
Paragraph 8.
Yes.
And then in A, it talks about mediation, and B, appraisal.
Correct.
So far as mediation is concerned, is there a very specific provision in the Florida Insurance Code that deals with that?
Yes.
And that is 627.7015.
I'll trust your word on that.
Okay. There is a provision, subsection in there that talks about a definition of claim, 9 B and C. B says it takes out of the definition of a claim where mediation would be required, where based upon agreed upon facts as to the cause of loss, there is no coverage under the policy. And then subsection C says, with respect to which the insurer has a reasonable basis to believe the policyholder has intentionally made a material misrepresentation of fact which is relevant to the claim, and the entire request for payment of a loss has been denied on the basis of the material misrepresentation. That sounds pretty familiar, right? That's yes, what you're attempting to do here.
Yes.
Okay, so the legislature specifically has addressed a situation under this kind of scenario and has said that for mediation, 8A, that when that occurs, mediation is not required. Am I reading that correctly?
I believe so.
Okay, so
having not argued on either side,
so
in the trial court.
The way I'm looking at this is that that specific provision for the exception, that specific scenario, is not specifically spelled out in the policy, but it's still incorporated by reference as a matter of law, is it not?
Yes.
So for when we read this policy, by incorporation as a matter of law, that specific provision that you're attempting to exclude under the appraisal situation is there for mediation, but it's not there for appraisal. So why shouldn't we then conclude that the legislature knows how to do this under these exact scenarios and chose not to? And the insurance company could have specifically put that language in the policy, but chose not to. So why should we then read into the policy something that's not there?
I don't think you have to read anything into the policy except what's actually in the policy, which is on page 11, which is the concealment or fraud. That's all either party has argued, and in fact, both the insured and the second DCA have agreed that we have that coverage defense. That hasn't even been an issue in all of the litigation.
Right, so the issue is really not whether the coverage defense exists or not. It's just a matter of when can you bring that defense, and does it somehow prevent the appraisal process from going forward under the policy? So there's no language that says something like this. Something like this would have done it. We have a right to deny the claim for lack of coverage or fraud before there's an appraisal. That would work when we wouldn't be here, right? But that's not there. What is there is if there's an appraisal, we still retain our right to deny the claim, which seems to contemplate that there's going to be the appraisal process going forward, and you still have this right to deny the claim for whatever reason. So why isn't that why shouldn't we read the policy in that way?
Well, in terms of that appraisal provision, what that is, for example, in the Kiet Investments case out of the 3rd District, a 1997 case where the fraud was not discovered until the appraisal process. And so that is a non-waiver of any fraud that may be discovered during the appraisal process. It does not override the concealment or fraud provision, which says that if we discover if there's any kind of misrepresentation, there's no coverage for the loss. You have to take those in paramateria.
Well, I don't think they're arguing that there's no fraud defense available. I think their argument is we should be able to follow what's in the policy and have an appraisal process, and you still get to assert your defense as well. Isn't that their?
That is their argument, Your Honor, but we believe that the court should follow the 4th District, which says that before you can determine damages, before you can determine the amount of loss, you have to determine liability. You have to determine coverage issues, because if there is no coverage, if there was concealment, then the whole appraisal process is moot. And
let me ask you this, counsel. It's hypothetical. Say where there's no appraisal provision, but everything else is the same. How's that going to be tried? You don't get a mini trial. Do you get a mini trial on your coverage before
no
anything else happens, or is that just a defense that's tried as part of the whole trial?
Correct. It's a defense that's, and in fact, it was asserted as an affirmative defense. A jury trial was requested both in the complaint and in the answer on all issues so triable. And by the way, the complaint doesn't even request appraisal. The complaint is for breach of contract for denying the claim and for declaratory judgment. Nowhere in the complaint does it request appraisal, but it does request a jury trial. So yes, these issues would be tried to a jury. The jury would determine, A, were there misrepresentations, among other defenses that were asserted, like we don't cover tennis courts. And if there were no misrepresentations, then what's the damage to the plaintiff, to the insured, just like any other insurance?
But all those issues would be tried to the jury, and then the jury would decide. And obviously they would have some order of deciding things when they go back. But
exactly, yes.
It's not like you get a preliminary determination on the issue of coverage.
No. Your Honor, I think, Justice Groshans, I think you had a question.
I was just going to follow up on Justice Polston's kind of line of questions there. Wouldn't it, I know you're so excited to go back to that, wouldn't it seem that at the very least the retained rights provision would indicate that you can concurrently run a loss of coverage issue with an appraisal, amount of loss issue? Because you're retaining the rights to deny. I mean, there are certainly cases, correct, in which you've had this appraisal before you ever deny the claim, because you could demand the appraisal. The insurance company could demand the appraisal immediately, correct?
Yes.
So this happens.
When they admit that there's a covered loss, that there's some covered loss, that they're going to cover something, they may say, yeah, we're going to pay for your roof but not your windows. And in that case, I think everybody agrees there can be appraisal, and it can be first. But under Johnson, even though Johnson was a causation issue, Johnson approved of Gonzalez from the 3rd DCA, and Gonzalez says that when all coverage is denied, it becomes a legal question for the court to decide.
Right, but I don't think there's anything in the 2nd DCA's opinion that says anything different than that. And Johnson doesn't really demand it be in a certain order. I know that the 4th interpreted Johnson to say that, but that's not really what Johnson says.
Ironically, the 2nd DCA's opinion I believe it was Heritage, which is now a tag-along case here, said that when there is a denial of coverage, there is no appraisal. There's no appraisal, period, that a court cannot send the case to appraisal. And that's because under Gonzalez, under Johnson, it becomes a legal issue for the court. There's no coverage. We're saying there's no coverage whatsoever. That now is a legal issue that the court needs to decide. because they denied appraisal, we're not operating under the contract anymore, under the policy. We're under whether there's coverage at all, and that needs to be determined by the trial court.
And that sort of gets to one thing that it seemed like there was kind of an ambiguity in terms of, it seems like in your brief you're arguing that once the coverage issue gets put on the table, that then it shifts everything over into the court arena, like the chief was asking about.
Yes.
And that the jury would, and or the court would sort of decide both things together. But then it seemed like in the cases there was kind of this assumption that, sort of an acknowledgement that the court process would deal with coverage, but that the actual loss issues, if you were to lose on that and then loss, the amount of loss became an issue, that the contract kind of gives you whoever invokes it the right to have that decided by the appraisal. And so in that sense, the trial wouldn't really preempt the appraisal as being the way that the loss is determined, and which really does make it a sort of kind of more of an efficiency question of, is it worth going ahead and deciding the coverage first versus whatever. So how do we, is there kind of a clear answer on that once coverage becomes an issue, that it necessarily kind of takes the appraisal off the table completely and makes the loss amount determination also for the court/jury?
I don't think the courts have spoken explicitly on it. A lot of the cases say something to the effect of the coverage needs to be determined before appraisal. But the actual directions really don't explain what happens on remand. I think the closest that a court has come to ruling, as I suggest, is ironically the second in the Heritage opinion, which is from February of this year, in which it was a supplemental claim. They denied the supplemental claim, and the court, despite the fact that it had decided Leeward Bay, it seemed to say, it said, however, when an insurance company wholly denies a claim, the trial court cannot refer that claim to appraisal. And then it said later, and since Heritage wholly denied coverage for that supplemental claim, Johnson and his progeny precluded the trial court from referring it to appraisal.
Yeah, and so I guess, and so that's my problem is, what part of the issue is, it seems like the courts that go down that path, in my view, are kind of over-reading Johnson. But do you agree that if you read the contract as giving the parties unilaterally to kind of invoke this right to have a dispute, almost like an arbitration type thing, to have a dispute over the amount of loss resolved through appraisal, then, and if we acknowledge the background principle that coverage is for the court, do you acknowledge that if we read it that way, that at the end of the day, once that's invoked, the loss amount is going to be determined by appraisal? Doesn't it just then become a timing question? It's sort of an efficiency thing, which brings me back to my initial question of, how could we tell a trial court that it's per se an abuse of discretion if it's just a timing question, to sort of do it one way or the other, as opposed to if making it a coverage, once you loop the coverage thing in, does that mean then that the appraisal is no longer available as a way of resolving the dispute over the amount of loss, if there is one? That seems like you're in a different posture then.
Yeah, that is our position, Your Honor, that appraisal becomes moot. But even if it's not moot, even if you say that that it'll proceed, certainly the damages cannot proceed until liability is determined. And in this case, and this gets into my second point, even if you're correct, or Justice Polson's correct, that appraisal can be ordered, it can go before, and it's discretionary, at least it should be exercised at the beginning of the case. Here, at the beginning of the case, in December of 2018, the trial court denied a motion to compel appraisal. It was not until March of 2020, 3 weeks before trial, after 19 depositions were taken, after discovery, after proposed jury instructions, motions in limine, all that needed to happen was the trial itself. Then the court suddenly changed its mind based on a PCA citation opinion and said, no, let's go to appraisal. So even if they're correct and it's in the discretion of the judge and it's not an abuse of discretion, that discretion has to be exercised at the beginning, not at the end, when any efficiencies have been eviscerated by then.
That makes sense to me, but they tried, right? I mean, they tried to get this done earlier
And the court
on.
exercised
and
its discretion.
And not to do it, I mean, this thing got delayed, and so I agree with your argument that this should not have been delayed as it should have been, but so what are we going to do now? Punish them and not let them have the appraisal process that's provided in the contract at all because the judge erred? That doesn't seem like the appropriate relief.
But even under their theory, the judge did not err. He had the discretion, and he exercised it by saying no. So now he re-exercises the discretion after all that litigation had occurred.
You're saying that your client has somehow been harmed by the judge not doing this quickly enough. Is that what you're saying?
I'm saying that the judge exercised that discretion at the beginning when it should be exercised, and all of this litigation now eviscerates any efficiencies that can be obtained by appraising it first and determining what the amount of the loss is first.
Okay, counsel,
I
as you know, you have exhausted all your time, but I'm going to give you 3 minutes for rebuttal.
Thank you for your generosity, Chief.
Good morning, Mr. Chief Justice. May it please the court. My name's Mark Boyle with the firm of Boyle, Leonard & Anderson, along with Amanda Broadwell with Cody DeBost. We represent the Riverside. So the insurance policy in this case, written entirely by the carrier and with no contribution from my client, contains a unilateral appraisal provision authorizing either party to the contract to demand appraisal. As the court's already noted, the appraisal provision specifically contains the following term. If there is an appraisal, we retain our right to deny the claim. Every single court in Florida, the Middle District of Florida, certainly in this storm cycle, that has considered the issue we're here talking about today, whether this claim of fraud can bar going to the appraisal, has ruled in my client's favor. So if the standards, we would respectfully submit, abuse of discretion, every panel of the second district, there are dozens of these cases, as the court knows, parked here from trial courts who are dealing with these Irma cases on a daily basis. They've all exercised their discretion in the way we're advocating for today.
I'm sorry to interrupt you. So if it happens the way you want, the appraisal process goes forward, and then that just kind of sits there pending the coverage issue being resolved by the court. And if the court says there's no coverage, then the appraisal thing was a waste of time. And if the court says there is coverage, then you just sort of take that off the shelf and plug it in as the amount. I mean, how does it work?
That's how it should work. And the court should have discretion. We shouldn't tie the court's hands about which one goes first. We're not saying that the trial court couldn't have. This came up with the second district oral argument. What if there was a claim of the fraud in the application for the policy, so the policy was void, or some other form of fraud that the court thought strongly about should be tried first? We shouldn't tie the trial court's hands in evaluating this.
And so what's your position on this, on what the chief was asking and that I was asking about? Once you invoke the appraisal, does that take the amount of loss question sort of out of the court arena?
It does.
Okay.
And that's what the policy calls for.
So you disagree, so to the extent that the other side is saying that you sort of do the coverage and the amount together and the court sort of process kind of takes over what otherwise would have been done by the appraisal.
I didn't hear my opponent say that today, but that is their position. That is their position in their briefs. That's their position at the trial court. Once they raise this fraud issue, appraisal is completely off the table. Everything goes to the jury. That's their position. So the core issue, as I noted in this case, is the discretion.
Let me just ask you, you mentioned over here, you mentioned that that there would be a basis for denial of coverage if there was proven fraud in the application process, correct?
That's correct.
And there are also many other bases for denial of coverage that have nothing to do with the disagreement over the amount of the loss, correct?
Correct.
Yeah, I mean, so with the judicially created rule that coverage issues come first, don't you think there's a distinction between coverage issues that have to do with anything else and, given the language of this policy, coverage issues that have to do with the amount of loss, because there is a contractual right to have that determined by appraisal?
So the broad answer to your question is yes. The difference in the application fraud that I conceded is under Florida law, that voids the contract ab initio, so even the appraisal provision would go the way of the dinosaur. So that's different. But the court's correct. There are lots of there are lots of coverage defenses, such as there's a wear and tear exclusion that's being asserted in this case. That you appraise the case over that, and they can come back into court and make their arguments about the wear and tear exclusion. Trial courts are, particularly in my home community, Irma went right over this property here, and the Naples courthouse, they've become super sophisticated about letting the appraisal panel know what type of information they need to help them evaluate the coverage issues when they go back. Sometimes they ask for a detailed appraisal award, sometimes they don't. The courts know, the trial courts know how to deal with these problems.
Is your argument any different if Weston had sought the return of the money they had already paid out?
My argument would be that the policy contemplates this either way. It says we retain the right. But for sure, my argument's stronger because this isn't a whole denial of coverage, irrespective of whether they're saying they denied the claim on a going forward basis. If in fact we committed insurance fraud, I would respectfully submit no reasonable person would not ask for their money back. This is not $4,000, this is $4 million.
So let me ask you though, so if we know that the coverage issue is going to have to be litigated no matter what, and we know that the amount of loss issue might go away if the coverage issue is decided adversely to you. So why would it ever be rational? Because at the end of the day, if it's an abuse of discretion, it still would have to be a reasonable choice for the court to bifurcate it and to have the appraisal proceed either concurrently or before. Why would it ever be reasonable to not start with the coverage and realizing that the appraisals, if you're right, the appraisal is going to have to determine the amount of loss anyway, but it might not even be necessary at all. So why would a court ever say, no, I want you guys to go and do the appraisal and spend your time and money doing that, and then no matter what that, at least legally, I mean, the insurance company might go away, but at least legally, nothing that happens there can resolve the need for the court to decide the coverage issue.
So we've all been talking about, and my opponent speaks of the appraisal provision in terms of efficiency, but there's nothing in the contract that says this appraisal should only take place if it's efficient. It's a contractual promise. And Judge Lucas brought up at our second district oral argument that there's nothing textually about the provision that conditions it on the efficiency that the court is raising. And in fact, he said, and I agree with this, having spent the first part of my career representing the insurance industry, there's a lot of reasons the insurance company might have that provision in their policy. One of them is they might not want to visit with a jury about the amount of damages.
Well, but that's totally irrelevant, though. If it would be relevant if you were talking about taking away, about having the court sort of take over not just coverage but also the amount of loss. But if you take it as a given that if the amount of loss needs to be determined, that it will be done through the appraisal, that doesn't speak to why, from a timing perspective, why it would ever be reasonable. Because at the end of the day, this is the question. Could a reasonable judge say, no, I'm not going to decide the coverage thing first. I want, I'm going to do what the party says and have them proceed together. Can you respond to that?
Sure. I was going to get there to the end. I apologize. I wanted to set the predicate. The amount of time and effort, the trial court was well within her discretion to believe, and I respectfully submit correctly so, that the trial over the damages portion of this case was going to be the biggest part of the trial, and that sending this case to appraisal first would reduce the amount of trial time it took to try this case. I'm not saying there's no overlap. There is some, for sure. So there could be some inefficiency in having both proceedings go, but we shouldn't try the trial court's hand. The other thing I would note is that the trial court's docket, the chief asked a question about could we try the damages first in the normal case if this provision wasn't here. It's pretty unusual. I don't think I've ever been involved in it, but Courts have the right to bifurcate matters all the time in their discretion. Sometimes we try liability first.
I think I was suggesting that you try the coverage first.
That's correct. I understood the court's question, but I would respectfully submit, even if what Justice Grosshans called the retained rights provision wasn't there, the trial court was within her discretion, and the trial court should be within their discretion to do that. And as the court noted, while the Fourth may think this court's prior cases tie their hands, there's nothing in this court's prior cases that speak to this issue. And if we raised a little bit of jurisdictional issue in our brief, as we did, all of the cases out of the Fourth, as best if you went through them, as best as I can discern, they're all cases where the claim never made it through the coverage grant, or the insured didn't comply with some condition prior to appraisal. They didn't give an examination under oath. I would respectfully submit there is no conflict. This court doesn't need to address this issue. The Fourth has never treated this fraud issue.
Do the conflict cases have the same type language in their policies that deal with appraisal, or are there any differing languages?
All the ones that I saw had the same language. Some of the language is not in the cases, to be fair to the court, so it's not 100% clear. But this provision it's pretty close to the gold standard in almost all modern appraisal provisions.
You want to Justice Muniz's questions
meaning the retained
about
rights provision. I'm sorry to interrupt.
the questions about efficiency. For whatever reason, your client in this case chose you really want the appraisal, right? Instead of trying their fraud claim first, you want to do the appraisal and have it all done, I guess, at the same time. Why is that? Why is it somehow better for your client in this case?
I don't want to give the court my entire work product, but for sure,
maybe just a little bit of it.
For sure, the trial court may have understood that sending this case to appraisal would get it resolved. The only one of these cases, the case that we cited as the PCA that got the trial court to change her mind, and by the way, they didn't tell the trial court the first time she had discretion to send the case to appraisal. They told her she could not, and that's what she believed. So the court's correct. They led her down that path. But that case went back, it was referred to appraisal, and it's settled. And it's not one of the cases that's parked here at the Florida Supreme Court. Part of the trial court's discretion should be to evaluate whether or not setting the appraisal first causes the matter to resolve. My overlying message, as I'm sure everyone can tell, is don't tie the trial court's hands with an artificial rule that's not called for by the policy or the contract.
That's the case. It's a dispute mechanism provision, right? I mean, that's what it's there for.
That's correct. And as one court recently noted, our system has, this is a quote, an overwhelming preference for the resolution of conflicts through extrajudicial means for which the parties themselves have contracted. This is all that we're here about. The appraisal process is strongly preferred. I should note, no carrier ever has to be in appraisal if they don't want to. There's nothing in the law of property insurance or statutes or the administrative regulations that require an appraisal provision in a property policy. Insurers typically put it in there. As I mentioned, Judge Lucas brought this up. They might not want to visit with juries, and that might be understandably so, and there's efficiency reasons. Better to have these, this is a multi-million-dollar claim, better to have it decided by construction professionals and people with adjusting experience.
And they could fix this issue if they wanted by changing their policy going forward.
To be more specific in the way the court noted, such as the mediation rule, or by having a bilateral appraisal provision. Those are quite common in the industry, where both parties have to agree to go to appraisal. And we have those cases cited in our brief. The carrier never had to be in this position. They're in complete control of the contract. Unless the court has any questions, I think the court understands our position.
Thank you, counsel. Rebuttal.
Thank you. It's not accurate to say that every court has held this way. Obviously, the Fourth DCA has held in cases that denied coverage, that coverage issue has to be decided first. in the recent case in Merrick Preserve, where the court, where it was not a total denial of coverage, the court recognized that the conflict regarding when there's a whole denial of coverage still exists between the second and the fourth. And in that case, in Merrick Preserve, said that in that particular case, the insurer did not wholly deny coverage, and therefore that dichotomy did not exist, and said it was okay to send to appraisal first. But even in the second DCA, the cases go a lot of different ways. In Leeward Bay, the court said that the trial court did not abuse its discretion in sending the case to appraisal. Then, in the Villaggio et Estero case, also from the second DCA last year, the court actually said the court abused its discretion in refusing to send it to appraisal, and that the court had to send it to appraisal. So now, removing the discretion from the court and saying, no, appraisal has to come first. And then, as I said earlier, now you have the Heritage Property case from the second DCA from earlier this year, which said that there is no appraisal if the insurance company wholly denies the claim. And so it's an issue that begs for resolution. We believe, to Justice Muniz's point, certainly at this late stage of the case, there are no efficiencies. We're going to deny the claim no matter what. And now we can be prejudiced because the appraisal may be based on what we say are misrepresentations that aren't going to go before the appraisers. They're not going to determine credibility of witnesses. They're not going to cross-examine witnesses. They're not going to, most of them don't even have witnesses. And they may not itemize the damage. A lot of times the appraisers just say, this is the amount of the loss. So if you have...
Maybe I missed something, but you still have your coverage defense.
You do have the coverage defense.
And if you prevail on your coverage defense, that all just becomes totally irrelevant, right? That's part of your point.
That is.
So I'm having trouble seeing how you're prejudiced.
Because if the jury wants to award something less than that and say, well, you know, we claim that.
Well, that just means you lose on your coverage defense. I mean,
well, but the amount of loss is now, according to some cases, and this court can clarify, under the appraisal, that amount of the loss is now set in stone, and we cannot litigate damages in the trial court. So that amount of loss can be based on a misrepresented claim. That's the prejudice.
Well, and that's that's sort of the big lurking issue that it seems like there isn't clarity on is the appraisal just there to be sort of plugged in, or does the trial take that over? But so if you look at the fourth DCA cases, it seems like the two reasons that they give to support your position are the Johnson case, which, you know, I think it's overread. And then there's the Engel thing. I think we would have to have our heads examined to build out anything more on Engel. Sorry.
You haven't heard me argue Engel.
No offense to the court on that. I mean, so can you give us sort of a succinct, what would the reason be for us to say it's per se an abuse of discretion to handle to let the courts decide?
Very succinct, because I know I'm over my rebuttal time. Before you can determine damages, you have to determine whether there's coverage at all. You have to determine liability before you get to damages. You can't do it backwards with the tail wagging the dog and say that damages are determined first. Thank you. And thank you for indulging.